This lesson will discuss the nature of the trust instrument with a focus on express trusts. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. To recall, the trust instrument originated in the Court of Chancery to soften the rigidity of common law by using equitable principles. As Parkinson acknowledges, the trust is complex and difficult to define because it allows for multiple interests and duties in the same property. A basic trust involves 4 key players.
Settlor, the original property owner.
Trustee, the holder of legal title. Beneficiary, the person for whose benefit the property is held. The court, which enforces compliance and fairness. As Roger Smith observes, the flexibility of the trust instrument allows to create different types of trust, depending on the specific need. This includes the express trust. As affirmed in 1986 in Goodman v. Gallant, express trusts are explicitly declared trusts, typically through a will or legal document. For a valid express trust to exist, the settlor must intend to create a trust. It must be legally permissible, and it must comply with the 3 certainties of intention, subject matter, and objects. Courts enforce these trusts in equity, especially to prevent fraud or misconduct by trustees. One of the questions raised with respect to express trusts is whether a trust is property. Parkinson argues that most scholars consider express trusts are a form of property right and not just personal rights, since the trust instrument uses property-related rather than personal rights language such as legal estate, equitable estate, legal ownership, and equitable ownership. This approach is adopted by English courts, for example, in the Privy Council case of Abdul Hameed Sitti Kadija versus de Saram in 1946, as well as US law. This is because a trust requires that legal and equitable ownership are recognized distinctly, and a trust cannot exist without property. It is fundamental to the trust's existence. Some criticism exists, especially in charitable trusts, where the beneficiary does not have a defined property interest. Yet the historical and practical ties between trusts and property conveyance, especially in land law, support the property view. Other commentators argue, in particular John Langbein, that trusts resemble contracts, particularly due to the agreement-like relationship between the settlor and trust. Langbein suggests that the trust is a deal, a bargain about how the trust assets are to be managed and distributed. Furthermore, Langbein finds a contractual aspect to the trust in its historic connection to failed covenants, which it came to correct, and medieval third-party beneficiary arrangements. Maitland supports this view by reminding us that trust enforcement practices have historically been based on the contractual nature of the trust instrument and the law of obligations. In modern times, the contractual aspect of trusts is reflected in the trustee's fiduciary duties, which resemble contractual obligations and are recognized in both UK and US law. Modern legislation, for example UK Contracts, Rights of Third Parties Act of 1999, reinforces this idea. In summary, a modern trust blends both property and contract law. It uses personal obligations, trustee duties, creates proprietary interests, beneficiary rights, adapts to different needs through a flexible legal structure. While the trust has contractual elements, it cannot be reduced to just a contract. It's a hybrid legal construct, a contract about how property is to be deployed, combining fiduciary relationships, equitable remedies, and property rights. It can be concluded that the nature of the trust remains doctrinally fluid, resisting a single classification as either property or contract. This flexibility is key to its continued legal and practical relevance.